Good morning, everyone, and welcome. We'll be starting officially at 10:30, but just as it takes a little while for attendees to obviously all register through, we just thought we'd open up slightly earlier this morning so that you can all process in and hopefully hear for when we start. So, yep, about 30 or 40 seconds, and then I'll start delivery. So if you're quick, you can probably grab yourself a glass of water. Okay, well, that's gone over to 10:30, so let's get started. So welcome everyone to this third EIA learning event on through the National Planning Improvement Service. Today we are going to be focusing on environmental impact assessment screening process, so deciding whether there is a need for EIA, and the aim is to enhance your confidence as planning officers and also your understanding of this area. So just some quick introductory slides for us to move through before we get on to the main event and content. So I'm Josh Fothergill. I'm a fellow of the Institute of Sustainability and Environmental Professionals and a chartered environmentalist. I've been involved in the environmental impact assessment field for well over 20 years now and spent nearly a decade working as the policy and practice lead on EIA for EIMA as it was at the time, which of course now has become ISEP. Been actively involved across various different EIA kind of practice areas, so kind of drafted the government guidance over in Northern Ireland, done various global reviews into digital technology and EIA, how the circular economy and EIA links together. And I'm currently volunteering with ISEP to produce some forthcoming guidance on cumulative effects within EIA. I'm also the founder and the chair of Scotland's EIA conference. So if you recognise the voice or the face, that's maybe you've been to the conference at some point over the last kind of 8 or 9 years. So welcome, you're very welcome to this series. Hopefully you've seen the previous webinars, but if not, there is opportunity for you to pick those up and play them again as part of the training programme. So we're doing the welcome and agenda at the moment. I'll run you quickly through the National Planning Hub EIA training programme and a little bit of housekeeping, and then we'll dive straight on for around 40 minutes on screening, and then we will have a Q&A, and we will close some point between 11:30 and 11:45, depending on how active that Q&A is. So the National Planning Hub is based and led by the Scottish Government. It's in partnership with the Improvement Service, and the Hub is tasked with providing direct support to planning authorities to enhance decision making and their understanding of the process. And there's been various different areas of the Hub that have kind of taken a lead around hydrogen, around housing. But one of the key focus areas that came out of the work to identify need was around kind of judging significance and particularly linking into environmental impact assessment. So we have a capacity building program in relation to that started back in November and will push through till at least the end of March. And there are web pages developing on the Improvement Services National Planning Hub page in relation to that. So you can see the current page at the moment, environmental impact assessment of the selection list down here, and some key information, including down the bottom. You can download and link to the previous recordings and web content. The link is there, but it's probably easier if you just type into Google Improvement Service or National Planning Hub EIA. It should take you straight there. Notably, these pages are going to evolve over time, so there'll be sub-pages. So in a few weeks' time, we will have a sub-page dedicated to the screening process, and the recording of this event will be available there, minus the Q&A session. And just to highlight, a call has gone out for EIA case studies. We have a template, and I can provide some advice and review in relation to that. So if you are a planning officer or you think your planning authority has an interesting EIA case study, we'd be very, very happy to hear from you. Finally, just in terms of housekeeping, your microphone and your camera has been disabled for the session and we are recording it, so this can be shared on the web pages, as I've said, and the Q&A that we have will be excluded from that recording. So feel free to ask any questions you wish. It's just planning officers and our team on the session. For those questions, please use the Q&A function. So the logo is Q&A like this. Chat is purely there if you've got any technical issues, but the Q&A if you've got any EIA related questions. You can pose them as we go along, and Andy Watts from the Improvement Service, who heads up the National Planning Hub work, will be asking those to me at the end of this process. So we'll read those questions out on your behalf. So yeah, feel free to use that as we go along, or you can post questions at the end if you wish to do that as well. And just as mentioned, any technical issues, then use the chat function. So let's go on to the meat of today, EIA screening, enhancing your understanding as planning officers and your confidence in relation to that. Our objectives are to provide you with a core understanding of different ways that a project can be defined as EIA development, and that's in italics because EIA development is a kind of word defined within the EIA regulations, and those are the projects that require an EIA to be completed before the prohibition to grant consent is removed through the EIA regulations. We're also going to identify how to identify those Schedule 2 developments. Schedule 2 developments are the ones where you guys are required to produce a screening opinion. So you need to decide in those cases whether EIA is required. And then finally, we're going to look at those activities around screening opinions. And we're going to touch on a few other areas you've raised in Q&As in the previous sessions about mitigation in screening. So we're looking at that a bit more. And we're looking at multi-staged consents briefly and some of the information and guidance related to that. So let's start off just with a refresher or reminder as to what environmental impact assessment is of itself. So it's a decision support tool. It's applied before we're determining a planning permission, and it's only for those developments that are likely to have significant effects on the environment. So EIA isn't going to tell you you can or you can't consent something. It's going to present environmental information that allows you to make a more effective decision. But we only undertake the process if the proposed development is likely to have significant effects on the environment. And therefore, that becomes a key element of when we're screening these projects. We're trying to judge, are they likely to have these significant effects? They can still have adverse effects and go through the standard planning system. So it's that judgment around significance that becomes a key aspect. We'll talk about that later. It's a legislative requirement. It applies across the UK's development consenting processes. So obviously within the planning system, as we're focusing on today, but also under the Electricity Works Act, also in the marine environment and various other contexts as well. And one of our later learning events will talk about some of those wider contexts. And what it does is it applies a more rigorous approach to environmental assessment for those projects that are posing a greater risk to either the environment or communities to provide that information into your planning decision process. So just to highlight what we're looking at, this is the process diagram I took you through in the first webinar, and this shows the whole of the EIA process from a developer, be they a public or a private organisation, coming up with a proposal, through screening where we're focusing on, and through the various steps if it's identified that EIA is required. In terms of today, where are we going to focus? Well, we're going to focus on this box here in terms of screening. That'll be our main focus. Is it an EIA development and needs to go through this loop of additional activity, or is it not EIA development and therefore it can continue to the through the ordinary consent process? Of course, in that ordinary consent process, we need to remember it doesn't mean simply because we've decided EIA isn't required, it doesn't mean that the environment isn't a key ground within a planning application. It can still be a material issue for the decision, even if EIA isn't required, and it can still be turned down on environmental community grounds, even if EIA isn't required. The crux for EIA, as we'll see when we get into screening, is that judgment around significance. So the other areas that we'll be aware of is where the applicant can, applies EIA themselves, just so that we're aware of other ways that EIA can occur. We'll note the fact that if we get to the submission of an application and it hasn't been screened for EIA, we haven't had that conversation, the developer hasn't come forward and asked for that information, then you need to undertake screening at that stage, and certainly before you get to the consent decision. Otherwise, you're putting that consent at risk should that consent be granted. And then finally, towards the end today, we'll talk about screening of what in EIA is termed multi-stage consents, but for yourselves, would probably be more familiar with the idea of planning permission in principle and then the approval of matters specified in conditions. And we'll use some of that terminology, of course, when we get to that section. So those are the areas we're going to focus today. Why is getting EIA screening right important? Well, there is a key legal risk that we need to be aware of. The EIA regulations, they prohibit you granting planning permission or this multi-stage consent to a development that requires EIA unless an environmental impact assessment has been carried out. Now, what that means is, obviously, if we have a project that's clearly needs an EIA and we haven't done that process correctly, then we could be in trouble. But it also means that if we have a project that could have required EIA, but we haven't been through that screening process, then again, we can still get into trouble if we grant consent. So if we have a Schedule 2 development, which is a development that might or might not require EIA, it requires a judgment from yourselves as the planning authority. If we haven't been through that process, then the granting of planning permission in relation to that development has a greater risk of being successfully judicially reviewed. So other things to be aware of, the regulations themselves. Of course, we're focusing on the Town and Country Planning EIA Scotland regulations. And you might think, oh, I know about screening. It's all in part 2 here, determining whether EIA is required, environmental impact assessment is required. And that is a very important part of the regulations to be aware of. But we do go beyond regulations 6 to 7 that are the content of part 2. So there's a whole range of different things we need to be aware of. Understanding some key terms as set out in regulation 2, understanding some of the components within that screening process, but recognizing that there are activities, and if an application comes in without having been previously screened at the start of part 3, then we do need to make sure that we're screening that for EIA. And then in terms of those consent decisions, those prohibitions, they sit in part 1, and the definition of EIA sits there as well. And then some of those requirements in relation to multi-stage consent or approval of matters specified in condition, those things can sit outside of part 2 as well. So don't just think that it's part 2 of the regs, the only bit you need to look at here. So let's look forward. What are the various ways that a project can end up requiring EIA? Well, there's a number of different ones. And the key term here is EIA development. If something is termed EIA development, that is a term that's defined in Regulation 2, and that means it requires an EIA, and you as the planning authority need to complete all those later steps that we outlined in the first 2 webinars and in our webinar on the 26th of February. We'll go into more detail as to what you do once an application comes in with the EIA report, etc. But what makes a proposal an EIA development in the first place? Well, the first aspect is if it is a Schedule 1 development, these always require EIA. Again, the term is defined within Regulation 2 of the EIA regulations, and what it basically means is the project is either meets or exceeds the description that is set out in Schedule 1 of the EIA regulations. And there's 20 odd different project descriptions that are in there, and these are effectively projects that the government has deemed will always be likely to have significant effects, and therefore it's been set out in law that they will always require EIA. These tend to be pretty big developments, some of them perhaps very unlikely to come forward now, like major new coal-fired power stations. However, new nuclear, there are things in relation to ports, there's things in relation to intensive farming and the number of poultry or sows, etc., that are on that intensive farm. There's pipelines and various other things. So if it's a Schedule 1, it always needs EIA. You shouldn't need to screen it because the law dictates it will require an EIA, but you need to be aware of those projects so you can pick them up. Of course, the developer should be fully aware of that as well. Now, the key area, the area we're going to focus on today, where screening actually applies, you guys needing to make a decision most of the time, is Schedule 2 developments. Now, a Schedule 2 development is a maybe in terms of it requiring EIA or not, and that maybe requires someone to make a decision. One of those decisions can be made by the applicant themselves. So if they think their project is very likely to have significant effects on the environment, or they see projects similar to theirs are all requiring EIA, they might decide to skip the time it would take to get a formal screening opinion and instead just simply decide to move straight on to the EIA process. Ideally, they'll inform you with that, but sometimes you might get your first information as an EIA report is submitted to them. That's an occasional thing that happens, perhaps more likely on renewable energy projects where, particularly onshore wind, that come to planning authorities where, of course, many EIAs have been undertaken on previous type developments. The key area we're going to focus on is you guys making a decision. That decision as a planning authority is called producing a screening opinion, but there is the opportunity for the Scottish ministers to step in and produce a screening direction, and we'll talk about that a little later in relation to challenge. And then finally, development that actually sits below the Schedule 2 definition could, in theory, be required to have EIA, but that isn't something that you guys can decide. That's only something that the Scottish ministers have power for. So very small developments, developments of a particular size, if you're concerned about them, but they're not classed as Schedule 2, you as a planning authority could make a screening direction request to the Scottish Government if you felt that a project that appears to fall outside of the EIA regulations should undergo such an assessment. So let's move on to those Schedule 2 developments and think about your planning officer role and what are the tasks that you need to undertake. Well, the first thing we need to do is we need to be able to identify what are Schedule 2 developments. So this is the first task as we go through a screening opinion. To decide whether we're going to do a screening opinion, we need to decide if the project is Schedule 2 or not. So what is a Schedule 2 development? Well, again, it's defined in the legislation. A proposal is Schedule 2 development if it fits within the description mentioned in column 1 of Schedule 2 of the regulations. Those are different types of development, but it also must either have part of the red line boundary within a sensitive area. We'll come on to talk about what those are in a couple of slides' time, or it needs to be at or above any of the particular thresholds or criteria that are set out in relation to that type of development within the second column in Schedule 2. So it needs to meet the descriptive requirements and either be above generally kind of area type size thresholds, but there are a few other ones for certain types of developments, or part of it being a sensitive area. So let's break that down a little bit. So if we think about Schedule 2 developments, there are 13 different sections within Schedule 2, 12 of them named there, different types of industry. You can see starting off with agriculture, going through energy, chemical industry, food industry, infrastructure projects, which is also where urban development sits, so housing projects, and then other and tourism. The reason I mentioned 13, although there's 12 on that list, is because changes or extensions to existing activities, forms of development that are listed above, or that are listed in Schedule 1 can also be brought in under the Schedule 2 development. So under each of these, there are subheadings with more detailed description of different types of energy industry. However, we found out from case law over the years that it's important not just to read the specific requirements, but also take a bit of a broad view or wide scope and a broad purpose, as has been mentioned by the courts. So if you look under 3 energy industry, there's a whole load of subcategories, but you won't see anything for solar energy production. However, numerous solar projects and solar energy projects have undergone EIA with the application of this wide scope and broad purpose. And also you'll see waste industry listed in the subcategories of one of those areas, but recycling plants are considered to be part of that. So we need to take a broad view when we're looking at these activities. So firstly, is it in one of these areas? If it is, great. We then need to look across, and here's an example from infrastructure projects. So we can see it needs to be an urban development project, so that might be housing, but it could be a shopping centre, car park, etc. And its area of development exceed 0.5 hectares. So if it is over 0.5 hectares, then we will be covering it. So that is one way. It is an urban development and it is over 0.5 hectares. It's a Schedule 2 development. we need to produce a screening opinion. The other area is it may be an urban development or an industrial estate, and it's only 0.3 hectares, so it's below this threshold. However, there's a scheduled monument on the site, a standing stone or something, or it just goes slightly into a national park, or it's entirely within a national park. So if we have developments that sit within any of these specified sensitive areas and they meet these descriptions, then again, we need to be screening. So for those local authorities that have a large area of their patch that is national park or national scenic area, or there's a number of triple SIs, SPAs, etc., then we need to be aware that there's far more screening for EIA will need to be undertaken in relation to those types of applications coming forward. Just to clarify, sensitive area, again, is a term that is defined in the regulations. So it means and is limited to these areas here. So triple SI, SPA, special area of conservation, etc. So if you have protected area, particular designations and protections that sit outside of those, they're not sensitive areas in terms of defining a Schedule 2 development. They can still be important factors if we find we are screening, but they're not something that would trigger the definition of a Schedule 2 development. So the first task is there, identify, is it Schedule 2, therefore do we need to go on to screening? Moving on to our second task, we now need to work out, well, okay, if we've identified it as Schedule 2, we now have to undertake a screening. Let's think about who is going to be involved in that process. So there's certain parties who are involved by the regulations, and there are certain parties that are not required by the regulations. And some of those might surprise you because you might be contacting them on a fairly regular basis. So in order to produce a screening opinion, who is involved? Well, the developers involved, or possibly some consultants working on their behalf, they have to provide certain information in relation to the development, environment, and effects, so that you yourselves as planning officers in the planning authority can make the decision and produce a screening opinion. And in relation to the EIA regulations, those are the only two parties who need to be actively involved in the screening process. So the regulations don't require the consultation bodies, that's adjoining planning authorities, NatureScot, SEPA, Historic Environment Scotland or Scottish Water to be involved. And I know that sometimes planning authorities do contact those bodies, but the regulations expect the decision to be able to be made by yourselves. You know, it's a planning judgment that is based on information. And I can understand why we might want to try and get kind of more advice from those bodies, but if we're putting those requests to those bodies, we do need to be aware that we're putting more strain into the system than the legislation is necessarily expecting in terms of resource demands. The others who don't need to be involved are the public, other stakeholders, interested parties, but the reason there is a little star there is that your screening opinion does need to be made available on the public record. So the outcome of the screening process needs to be made to the public, but the public themselves don't need to be involved in that actual activity. So let's just delve into that developer's role a little bit more. You can see the regulatory reference up the top there if you want to find where this is in the EIA regs. So the developer can make a screening request. So pre-application, they can ask, does my project require an EIA or not? Of course, if they don't make that request and a planning application is made, then there is still the need and a responsibility on yourselves as a planning authority to screen that project if it's Schedule 2. If they make the request, or at the point that the application comes in, then there's certain information that they must provide to enable you to make that decision. And this was added in 2017 to strengthen, I guess, the polluter pays principle that the developer should be providing you with the useful information you need to make your screening decision, rather than you guys having to go off and try and make that judgment, or that passing out to kind of queries of the consultation bodies. So they should be setting out where the development's located with a plan of sufficient detail to identify that land. They should explain some of the key characteristics of the proposed development in terms of demolition works, construction activities, but also its location in relation to other things that already exist in relation to environmental sensitivities. They're meant to give you an indication as to what aspects of the environment might be affected and highlight if they think any may be significantly affected or not, and then give some information in relation to whether they think there are significant effects or not. Of course, everything that they submit is likely to conclude it's not a significant effect because they are seeking to, they're generally obviously hoping that it's not EIA development. You can't take their word for it. You do need to make a judgment and read across the information that is presented there. So just because they say it's not significant doesn't mean that you have to accept that. In addition, the developer can describe various mitigation measures or activities. The regulations indicate those should be to avoid or prevent significant adverse effects, but of course the developer is open to put anything they like in their application, so there will tend to be a lot of mitigation in there, but as we'll find later, perhaps we can't use all of that mitigation. So let's now move on. We've had a request or we've got an application in, we've identified it through task 1, it is a Schedule 2 development. What do we have to do in relation to making a screening opinion? Well, the first thing is, if the developer hasn't submitted the information that's needed, you can go back, you can request it, and you can stop your screening clock in relation to that in order to get that information. However, be aware that if, whilst your clock can stop, the opportunity for the developer to go to the Scottish ministers is still open within that timescale, once that timescale has passed, sorry. So your second task, we've identified it's Schedule 2 development. What do we need to do? We need to produce a screening opinion. Planning officer has 3 activities within this task. They are judgment, making a screening judgment. And this is effectively making a judgment as to whether the proposed development is likely to have significant effects on the environment. That is the crux of the screening decision process. If it's not deemed likely to have significant effects on the environment, it's not EIA development, it's going to move forward as a standard application. If you deem it likely to have significant effects on the environment, then there's going to be a need for EIA. So it starts with judgment, reading across the information, etc. We'll look into each of these tasks in the coming slides. The second one is actually producing the opinion as a planning authority. So writing up your judgment and putting alongside that the core justification and evidence. And this information, the judgment and the evidence, makes up your screening opinion. And then the final task or activity in this task, is screening communication. You need to make the above screening opinion that comes out of activity 2 available to the developer, so you've got to send it out to them, but also you need to make sure it's placed on the public records. And that might not be something that sits with you as the planning officer who's made the judgment, that might be other people in your department or even in a separate team. So we need to be aware of that, and we need to be kind of making sure that happens. So let's dive into these activities and related factors a little more detail. So activity 1, this screening judgment. Well, it's about the application of your professional judgment. Do you consider that the proposal is likely to have one or more significant effects on the environment? If you do, it's EIA development. If you don't, it's a normal application. Of course, the environment is still potentially a material issue within that process. In order to do this, the regulations have certain expectations on you as a planning officer. As part of your judgment, you need to consider the criteria that are set out in Schedule 3 of the EIA regulations. We'll talk about those on the next slide. You need to look at any available results of relevant assessments. So the site might have come forward previously, had previous screening judgments or work on it. It might have been allocated in a plan and have a strategic environmental assessment finding in relation to it. If they're available to you, you should be considering those. And then the other thing you need to consider is the information the developers provided to you as part of your decision. Of course, you can go beyond that, but those are the minimum requirements that the regulation requires you to consider, and therefore, in your opinion, those are the things that you should be indicating you did consider so that you're demonstrating compliance. So let's think about those Schedule 3 criteria, and let's think a little about significance as well. So Schedule 3 is all about helping us make those judgments around significance. So it's set out in 3 different headings. It's set out in relation to the characteristics of the development, the location of the development, and then characteristics of potential impacts. And what we effectively have there is 3 components. what change is going to occur as a result of the development, what baseline and environment is there, what receptors exist that could potentially be affected, and then the final one is what are the potential consequences? So how might those changes and the receptors come together to have a consequence and effect? And then we need to make a judgment as to whether we think that is just a standard type effect that we might see in an ordinary planning application, or whether we think there is a greater risk, a significant effect. What I'd say is there's probably no single criterion there that is going to lead to your conclusion on significant effects. Really, your judgment should be drawing across how is the development going to change something, maybe in construction, maybe in operation. What is the sensitive receptor that is at risk, be it a site, a species, a community? And what is the consequence? Is this short-term, long-term, permanent? All of those factors should be playing through your head when you're thinking about these significance judgments. Let's move now on to activity 2. We've made our judgment. Perhaps we've decided, yes, it is a significant environmental effect, or there's at least one. We need to move forward in relation to that. Well, our second activity is making the screening opinion. And this is literally just writing up our decision, but it isn't just yes or no, it's EIA development. It needs and requires through the regulations to be justified. We need to use evidence to show how we've concluded that EIA is required, or that it's not EIA development and it's not required. So this document needs to be produced by the planning authority, and it's writing up into an opinion. It needs to include the opinion itself, and that really should be clear. I see many examples of screening documents and screening opinions and letters where I'm looking through it and trying to find where is the actual text that says this is not or this is EIA development. Sometimes it's right there up front. I always find that really useful. Sometimes it's kind of much further down. Sometimes it's emboldened. That's useful. Sometimes it's not, and it's buried in a few pages of text. So clarity, is it EIA development or is it not EIA development? So you need to state that clearly, but then you need a written statement. And this can be in the opinion letter itself, or it can be a separate document. So it could be your template that you've produced. And this is a written statement that refers to the Schedule 3 criteria and the assessment you've done to give the main reasons that you've concluded that it is or isn't EIA development. And remember, that links to significant effects, so you should have those conclusions linking to what issue you think is significantly affected, if you're saying EIA is required, or issues, or you should be indicating kind of how you've come to the conclusion that significant effects are not going to occur if you conclude EIA isn't required. If you're going to conclude it's not an EIA development, but only as a result of measures proposed by the developer to avoid or prevent a significant adverse effect, what we might term mitigation, then you need to set that out clearly within this statement as well. But that's only if it is avoid or prevent mitigation that has led to your conclusion of not EIA development. And we'll come back and revisit. In fact, we're going to look at mitigation in screening on the next couple of slides. So it's come up a number of times, has this question of where does mitigation sit in screening? What can we and cannot use? So mitigation isn't actually used in the EIA regulations. The terminology is measures to avoid or prevent a significant effect on the environment, but we commonly will call it mitigation, and generally that's what the developer is going to set it out as within their application document. But there are numerous types of mitigation. There's generally a hierarchy: avoid, prevent, reduce, and offset or compensate. And in screening, we're only meant to be looking at those that avoid or prevent, because that would remove the effect in the first place, and it wouldn't happen, as opposed to something that reduces or compensates, where the effect will still occur, but maybe of a smaller scale, or we might be trying to offset it. But that effect could still be deemed significant. So to make cleaner judgments, that is why mitigation and screening should be about avoidance or prevention. So not all mitigation that is set out in the developers' documents that they submit is going to be relevant for your approach. And the EIA regulations, the circular and the PAN, so the circular from 2017, the planning advice note from 2013, they all only refer to those two types of measures, those that avoid significant adverse effects, generally by removing the particular elements of the development, the proposed development that would cause those impacts, or by preventing those significant effects, disrupting the pathway between the new development and the receptor that would be significantly affected. So let's look at some scenarios, because this might be concerning some of you. Is mitigation relevant? And equally, is it even mitigation? Because some things that a developer might term mitigation actually may not be in terms of what you need to use in your judgments. So our first scenario, your judgment is that the proposal on its own is not going to have any significant adverse effects on the environment. You've looked at, and yes, the developers witted on about mitigation, that was all lovely, but actually just the core proposal you don't think is going to have significant adverse effects on the environment or significant environmental effects. Then mitigation is irrelevant because you've already concluded the development as it stands is not significantly affecting the environment. So it's not EIA development. So then we don't need to include mitigation in our written statement, because if we include it there, we're only muddying the waters. We have concluded the proposed project is not significant. So remember, effects that you judge to be adverse may not always be significant. There can be adverse environmental effects. You don't have to conclude that they are significant. They might just be common adverse effects that happen as a result of development. The second scenario, your judgment is that the proposal would have had significant adverse effects on the environment, but for some specific design features or some particular measures that are set out in the developer's information that avoid or prevent that adverse effect. In that scenario, mitigation is absolutely critical to your screening opinion and the communication. So you're going to need to include those measures in your written statements. We were concerned about significant effects here, but because the developer is designing it in this way, or because of these actions that they've indicated they'll take, we conclude that that significant effect will be avoided or prevented, and as a consequence, we are happy that this is no longer EIA development. The third scenario is where things, I guess, get a little bit more grey and needs a certain amount of professional judgment from yourselves. But in this case, you've concluded the proposal would have had significant adverse effects on the environment, but for specific design features or measures that only act to reduce or offset the related activities. Well, this is where we get into non-compliance risk. So if they're only reductive mitigation measures or offsetting or compensating for something, then we can't rely on them. This isn't something that the regulations allows for. So if we allow this proposal to move forward as non-EIA development just through the standard process, then there is a potential risk that it's going to get challenged and there could be a successful judicial review. But what we do need to apply our professional judgment on, and this is a critical point, is when we're deciding and reading the description of the proposal that's been sent in by the developer, they might set certain things out as mitigation, when actually they're just describing common construction or operation methods. They might be describing how they're going to demolish what's already on site and set that out as if it's mitigation, whereas in reality that is just a standard construction method or demolition method and activity, in which case those activities, they are part of the project itself rather than being specific measures to protect the environment. So that's where we sit there. Hopefully that gives a degree more clarity. Also wanted to talk briefly about templates. These can be screening checklists or template screening opinion letters. So checklists can be very helpful. They can be a really helpful record for your thinking that you've added through the process. But the format of many checklists will set out each of the criteria within Schedule 3 simply in a list format, and generally ask in the first column, is this relevant? And then in the second column, is it significant? And please justify your answer. They're not going to help you, therefore, in making your judgment, because as I mentioned earlier, your judgment is going to draw across a number of those criteria, something particular in the description of the development, maybe a construction activity, linked to something particular in the environment that exists at the moment, a particular receptor or a number of receptors, and then something in the way that they will relate to each other in terms of the environmental effect, the long-term nature, the permanence, the accumulation with other projects, etc. So they're useful for recording thinking, are many of our checklists, but not necessarily going to aid our judgment. We need to apply thinking on top of it. And we therefore need to think about the criteria across Schedule 3, but we don't have to necessarily. We need to think of the relevant criteria. So some of them we can skip over quite easily if they're not particularly relevant to our projects, whereas others we might need to put more thinking in when we're producing these checklists. So don't think you have to fill every box to the same level of detail. If there's contaminated land issues, that might get more detail than other areas where perhaps your inland and marine sensitivity therefore isn't relevant. In terms of our templates for screening opinions or screening letters, we need to be aware that our templates can become quite outdated quite quickly. I've seen quite a lot of templates or letters recently from Scottish planning authorities that still refer to an environmental statement, whereas we turned that terminology in 2017 into EIA reports. And equally, do we actually confirm that we got all of the Regulation 8.2 content from the proponent? These are the requirements that should have been submitted as part of the screening request or the planning application. So are we using the right terminology from the regulations? Are we confirming that we looked at Schedule 3 criteria, etc.? And as I mentioned earlier, they rarely get to the point in my experience of them in terms of clearly and upfront saying our conclusion is EIA development or not EIA development. That's what the developer wants to find. That's what anyone who's on the public record wants to understand, and then go into your justification. So maybe with some authorities looking, if you have time, at some of those templates. So let's move on from there into the third activity. So we've applied our judgments, we have produced our scoping opinion, we now need to communicate that opinion. We need to ensure that the screening opinion is both issued and accessible. Issued means sending it off to the developer. Accessibility is about putting it on the public record. And this can easily be missed as part of the EIA regs because Part 2 considers screening. Everything we need to do there, well, as we said up front, that isn't always the case. It's actually Regulation 28 that addresses the availability of opinions for inspection. And these can be screening opinions, these can be scoping opinions from later stages or various other activities. Regulation 28 indicates that the planning authority must make copies of its screening opinions available for inspection on a website and at all reasonable hours at the office of the planning authority where the public register may be inspected, and they need to remain on that register for at least a period of 2 years. So in terms of our communications, there are 2 elements that we need to be aware of. And just in relation to that communication, or how quickly we need to get to that communication, how long does it take, or how long are we allowed to produce a screening opinion? Well, it does depend. And this is one of the complications that kind of came in from the 2017 regulations because some other parts of Europe were having significant delays and not necessarily producing screening opinions in a quick manner. So the standard requirement stayed the same as it always was. 21 days, you receive the developer screening request, and is it a valid request? Have they sent the information in that was expected? So as we talked about earlier, if they had, then the clock has started on your 21 days. If it didn't have all that information, then technically maybe it wasn't a screening request and you can go back to them and find that. But 21 days is the standard expectation, which highlights the fact that this should be in most cases, a relatively quick judgment that is just you using your professional opinion rather than needing to go and consult others. We can extend that to 90 days, but that extension needs to be agreed in writing with between yourselves, the planning authority, and the developer. And there is the exceptional circumstances opportunity within the regulations that you can go beyond 90 days. But the only way to do that is you need to provide a written notice to the developer and justify the extension and indicate a specific date when you will adopt a screening opinion. If you fail to adopt a screening opinion by the relevant deadline, then the developer has the opportunity to seek a screening direction from the Scottish ministers, and that can trump, that would trump your later screening opinion if you made one. So it is important that you try and meet these deadlines, but to be very, very clear, it isn't, oh, it's been over 21 days, we didn't get written permission from the developer, EIA law no longer applies. EIA law still applies, that prohibition to grant consent is still there. So if we haven't screened and we're outside of these timelines, it is more important to get it screened. That is the kind of preeminent requirements that we need to be aware of in our heads. So the other thing I wanted to mention here was the existence of joint requests. So a developer can come to you and ask for a screening opinion, is EIA required, and a scoping opinion. If it is required, what should I be including in it to produce my EIA report? They can put both of those requests into a single letter to you. And this is how you would go about dealing with that. And it's pretty obvious. You deal with the screening first. You deal with that as normal, as we've just described. Is it a Schedule 2 development? If it is, it needs a screening opinion. Okay, and then we make our judgments, we do our opinion, and then we communicate it. The difference here is if we've identified EIA as required as a result of that scoping, that screening opinion, then we immediately move onto the scoping request as if they'd sent in a letter on that day that we made the screening opinion. So we then move on to scoping, informing the statutory consultees, etc., and we'll focus on scoping an EIA on the 12th of February in webinar 4. So I won't say any more about that here, but there is that opportunity, so they can do a joint request. So let's briefly look at the challenge that can arise as a result of EIA screening, the challenging your screening opinion that you've made as a planning authority. Well, there are two different mechanisms for challenge. One of them is within the live process before you have made your consent decision, and this is for either the developer or a third party to challenge your screening opinion, to effectively approach the Scottish ministers and say, we would like a screening direction from you as the government that would sit above and replace the planning authority's existing screening opinion. So from a developer's perspective, if they're told they require an EIA and they disagree with your judgment, they can take that to the Scottish ministers and seek a direction. But equally, there might be third parties, an environmental NGO, a community group, who you conclude there is no need for EIA, they disagree, they again can take it to the Scottish ministers. The Scottish ministers will make a judgment as to whether they think it's valid to make their screening direction, and then if they do and they produce a screening direction, then once it's issued, it will replace and overrule any previous screening opinion that has been produced by yourselves. So that is the first means of, I suppose, challenge to a planning authority screening opinion. The other way it can happen is through the legal challenge process. And this would then relate to a consent that you've awarded. So you couldn't legally challenge something if you don't give it consent, but if a consent has been awarded, then in theory, and that's happened sometimes, a party can take a judicial review and they can effectively take that on the grounds that you failed to either undertake screening of a Schedule 2 development, or there was a failing within that procedure that meant that your conclusion that EIA wasn't required wasn't an accurate conclusion. And the courts will make a judgment, of course, as to whether they're going to accept that judicial review or those grounds in judicial review and make their judgment in relation to that. It is worth noting, I guess, one other area, which is if we go to an appeal through the appeals process, the reporter in that appeal has then become the decision maker. They've become the consenting authority, and EIA responsibility therefore falls on them as a result of that. So in those cases, you can see in the appeals process reporters making screening decisions because they have duties under the EIA regs like you would when you are making your planning consents. So just some quick examples of procedural risks in relation to screening. If you simply fail to screen a Schedule 2 development, so you simply forget to do it and you grant consent for that project, then there's a pretty big risk there because it was a Schedule 2 development and we've got no clear information as to whether it had likely significant effects or a judgment from yourselves as the decision maker. So the key message, don't forget, you need to screen all Schedule 2 developments. Another area where things can become problematic if there's material differences in the application or some surrounding circumstances that mean that a screening opinion that was given is different to the project that was consented. Now, this might be we gave a screening opinion on a site a number of years ago. That site stalled, the developer has come forward, they've changed a number of things in relation to their application, and we didn't update or consider whether we need to update our screening opinion. So that's an area where we can look, but also on occasions it can be there's been quite a time gap and maybe environmental sensitivities have changed that mean that we need to relook at that screening opinion. The third area would be where there's substantive inadequacies in our opinion itself. So we've made unreasonable judgments, or it's simply a tick box approach and there's no actual reasoning or justification behind our decision. So we need to make sure that we're making effective judgments and clear justification, but that doesn't mean we need to write War and Peace in relation to our screening opinions and their documentation. We just need to clearly justify the judgments and decisions we've made. And then the final area, although this would be a very weak ground in my personal opinion, would be if we fail to make the screening opinion or its associated justification available for the public. But that is part of the due process, so we do need to make sure those documents are going on the public records, because that is the opportunity for the public and third parties and interested parties to have access to environmental justice and understand our decisions. So would be a very weak ground to lose to lose a judicial review. However, it is part of the process we need to be aware of. Of course, we've also mentioned salami slicing, where a project we might need to look more broadly to understand the full project. I don't have time to talk about that today, but we have got an article. The second of our EIA explainer articles is looking at that issue of salami slicing and what is a project for EIA terms, and that will be going on the website shortly, and that will appear on the screening subpages once they're available. So let's quickly move on to two final areas, the approval of matters specified in condition, or as EIA terms it in the regulations, EIA and multi-stage consent. And then finally, we'll close off with guidance before we move on to the Q&A. So if we have a project that has got planning permission in principle, and we're now looking at approval of matters specified in conditions, and it previously had an EIA report submitted to it. So it was an EIA development and the planning permission in principle had an EIA report submitted, then it's a different approach that we take in screening. We're effectively using our further information powers, our supplementary information request powers. We look over the information we had previously in relation to the environmental issues. We look over what matters we're being asked to approve that were specified in conditions, or as EIA would term it, we look over the multi-stage consent application, and we make a judgment as to whether there are any significant effects, any environmental issues that haven't been picked up in that previous documentation. If we feel there are issues that are missing, then we use our supplementary information powers under Regulation 26 and we request that additional content be provided. And then, of course, we'll have to consult on that and take that into account as part of our judgment. But if we feel that the conditions that are being asked for approval have no relation to the environment, or those conditions link into something that was assessed and has already been considered in the planning application in principle, planning permission in principle, then we can move forward without necessarily needing additional content. However, if we have application for approval of matters specified in condition and an EIA report has not been previously submitted, but it is a Schedule 2 development, then we are still going to need to go through the screening process. So in this kind of case, if we have Schedule 2 developments and we've got that application of matters specified in condition, then we are going to need to apply what we've been discussing in terms of that standard screening approach of making a screening opinion and making the judgment. You will tend to see far less screening requests in relation to this, but Part 8 of the regulations is quite clear that these do need to be screened. Finally, to touch on guidance before we just do a summary and move on to the Q&A. In terms of guidance, screening is touched upon in a number of Scottish Government and statutory body documents. So it's mentioned within Circular 1 2017, and also within the 2013 Planning Advisory Note on Environmental Impact Assessment. So you can go and find the links into screening in those. And equally within Historic Environment Scotland and Nature Scots joint EIA handbook, their third edition of that, that came out, I think, in 2023, I think. Anyway, that document also has some discussions and some perspective on screening that you might want to look at and consider. In terms of a dedicated advice note or government document in relation to screening, you don't have one of those in Scotland in the planning system. Over in Northern Ireland, there is one produced in December 2023, Development Management Practice Note 9B on EIA screening. Of course, that isn't going to be directly relevant. It is Northern Ireland specific. However, it does go into screening in quite a bit of detail. So if you want to kind of understand principles around screening and go beyond the 2 or 3 paragraphs in the Scottish guidance, then you might want to have a look over the Northern Irish document. But of course, consider that in your Scottish context. It's not going to refer to the right regulations necessarily. So just in terms of review, we've looked at enhancing your confidence, hopefully, and understanding of screening. We've considered the different ways that a project can become EIA development, how to identify and schedule 2 developments, and then those activities of judgment, producing the opinion and communicating the opinion in relation to those screening opinions you need to produce. And then we've talked a little bit around mitigation, multi-stage consents or approval of matters specified in condition, and we've talked a little bit about guidance and templates. In terms of this capacity building training program, our next steps are we have at least 3, very likely 4 webinars coming up. So 2 in February, we'll be looking at scoping in the EIA process starting on the at 10:30 on the 12th of February. We'll be back 2 weeks after that on the 26th of February, looking at what happens to EIA applications from the submission of the application and EIA report through to the consent decision. And then we'll be coming back on the same dates, but through March, looking at various other topics. And please do check the NPH EIA web pages because new articles and diagrams will be going up through that period as well. But now over to you guys